Good afternoon, everybody. Thank you so much for joining us today. Welcome to Fraser Jones Ireland's Employment Legislation webinar. This is the third in our series with the fabulous Hilary O'Connor. And thank you so much if you're a return attendee, and welcome if it's your first time joining us. It's great to have you here. So my name is Claire Schindler. I'm the Regional Director for Ireland here at Fraser Jones. We're a global specialist HR executive search and recruitment consultancy. And at Fraser Jones, we place talented HR professionals with all sorts of organisations, from startups and SMEs to global FTSE organisations. And we support both the permanent and interim market. I lead the business, and I've been in the recruitment industry in Ireland for over 25 years. Fraser Jones is a global consultancy. Along with our offices in Dublin, we also have offices in London and across the UK, Europe, Australia, Asia, the US, and the Middle East. So we're uniquely placed to support global organizations with all of their HR talent requirements. And as HR professionals yourselves, you know that employment law cases and decisions have significant impact on HR policy. So to give us some insight, Hilary O'Connor is here to review some important decisions made so far in the first half of 2024. Hilary will be covering the Flexible and Remote Working Code of Conduct and the AI Act and how this will impact employment law. Hilary will advise us on how this will impact our own organisations, and she will also give us some tips and takeaways. So I'm very pleased to welcome Hilary today. She's a solicitor and legal consultant, and you may be familiar with her from her series of straight-talking legal advice posts and reels on both Instagram and LinkedIn. She's a highly accomplished legal professional with a keen interest and significant experience in employment law. She qualified over 18 years ago and was elected to the Law Society Council of Ireland last year. A little housekeeping before we kick off. If you do have any questions during today's session, please add them to our Q&A box and we'll answer those questions at the end of the session. Hilary will also share her slides with all attendees and will record this session for you, your colleagues, to access later. So I'll now hand you over to Hilary, and I hope you all enjoy the session.
Thanks, Claire, and good afternoon, everyone. I'm delighted to be here, and thanks for joining us on a Monday. I know it's your lunchtime, so I am very appreciative of giving me this time. So we're just going to review, leading from where we were in February, Claire, we talked about the remote and flexible directive and the code of conduct from the Work Relations Commission. That was due in January and it was published on the 7th of March, which was after our February session. So I'm covering that, and I'm also going to look at the AI Act and how it will impact employment law. So it's the slides will be good for those of you attending today, just as to look at, and you can use them as a guide for your own offices and for your own workplaces. So I'll just push on and we'll run through it. There is flexible and remote working. There is lots of similarities between the two. So just bear with me, there are some differences, but it might seem like, oh, these are the same slides. It's because it's kind of the same criteria. So we'll push on and we'll deal with the right to request flexible and remote working. So it's covered in the Work-Life Balance Act in 2023, the right to request flexible and remote working. So as I said, the code was published on the 7th of March 2024, and the purpose is to give guidance to employers and employees when considering requests for flexible and remote working arrangements. And it's to promote a fair and transparent process for handling such requests. There was much hysteria at the time when this came out as to how employers were going to deal with it and how employees were going to request it. So this code of conduct is just as a guideline. So taking you through the detail of it then. So what is flexible working? So it comes from the Parental Leave Act. Flexible working is where an employee's working hours patterns are changed through flexible working, remote working, or changed and reduced hours. The types of flexible working, they include part-time work, term time work, job sharing, flexi time, compressed working hours, and remote working. And they are considered further in the code if you want to see what's what. But a lot of them are self-explanatory. So the right to request flexible working, an employee must be the parent or loco parentis of a child under 12 or 16 if that child has a disability or illness, and who will be providing care to the child, or provide care to or support to the employee's child, spouse, or civil partner, cohabitant, parent or grandparent, sibling, or a person other than one in the categories already specified, who lives in the same household as the employee. The person must also be in need of significant care or support for a serious medical reason. So you can see there that that's quite a wide-ranging category of persons. And but in order to get this flexible working, you have to be 26 weeks continuous service. You can apply for it before the 26 weeks. You can apply for it, in fact, on day one, but you won't be entitled to take it until you've got the 26 weeks continuous service. Okay, so moving on. Making the request then for flexible working. So you request in writing or online not later than 8 weeks before the arrangement is to start. So if it is for caring for a child, you must include the birth certificate, because remember, it is age dependent. So it's under 12, or if a disability or illness, it's 16. So if the care is because of a medical condition or illness, you set out who the care is for. So what category person. Include the medical certificate specifying the illness or such other evidence as to assist the employer in considering the request, and the nature of the care required, and the expected duration of the care, and the kind of flexible arrangement you're suggesting. So again, this is about giving the employer information so they can consider the application or the request. And so the more detail, the better for assisting the employer. Okay, so the response to a flexible working request. So they must respond within 4 weeks, which can be extended by another 4 weeks. So the employer must either approve the request and provide the notice in writing to be signed by the employer and employee, setting out the details of the arrangement, refuse the request and set out the reasons for the refusal, or request more time and specify how long you require. The employer must keep the signed agreement and send to the employee. So when considering the request, the employer can consider the needs of the business, the request, and the reasons from the employee, and must consider Part 2 of the code when considering this request. So changes to flexible working then. If it's agreed in writing, the arrangement may be postponed, varied, or changed. So it's all about this signed agreement. When you say, if it is agreed, then you have a signed agreement for the employee, for the employer, and that will set out the parameters of this arrangement. And that's important because you have the certainty in respect of the flexible working. So again, that can be varied, postponed, or changed. Now, termination. So an employer, just go back, sorry. So an employer can terminate an approved arrangement before or after it is started if the employer is satisfied that the arrangement would have or is having an adverse effect on the business. Now, this is important. So the employer can give notice terminating the arrangement, having considered the business, the employee's need, and the code of practice. The notice must set out the reasons for termination and specify the date on which the employee must return to the original working arrangement. This date must not be earlier than 4 weeks from the date of receipt of the notice of termination. So the employer who proposes to give notice of termination, so if you're ending this, you must first notify the employee in writing of the proposal to terminate the arrangement, and include details of the grounds for terminating the arrangement, and give the employee 7 days after receipt of the notice to respond, and then consider any response made by the employee before deciding whether or not to give notice of the termination. The employer's reasons must be clear, objective and reasonable. They should set out so the employee can understand the reasons. That is quite important. So you can see that the common theme in this is all about communication, being clear, concise in your reasoning, both from the employee's perspective and the employer. Okay, so penalisation probably doesn't need to be said, but just for ease, an employee cannot be penalised for availing or requesting the flexible working. If there's breaches, you can make a complaint under the employer's grievance policy or make a complaint to the WRC. Then crucially, the complaints to the WRC can be made within 6 months and then can be extended to 12 months of the decision. The WRC will only adjudicate on the process employed by the employer and not on the merits of the decision. That's quite important. And I think that is, we're getting a flavour of where the WRC will see claims on this. So that's why the process is important, because the WRC have indicated here and again with remote working that they won't interfere in the employer's business and why you have refused or you're terminating a flexible working arrangement. But they will interfere if you haven't adhered to the process. So those timelines are important, and consider, so your thought process, all of that is important, or the timeline. So the 4 weeks and all of that, you need to be tight with that, because if there is a complaint, then you want to be able to show and demonstrate that you've adhered to that. So I just want to emphasize that. And then your record keeping, you have to keep these records and arrangements for up to 3 years for each employee, and that's with each request, or face a fine of £2,500. So that's it on the flexible working. Then we're going on to remote working. So here the definition: remote working is an arrangement where some or all of the work ordinarily carried out by an employee at an employer's place of business under a contract of employment is provided at a location other than at the employer's place of business, without change to the employee's ordinary working hours or duty. So the right to request remote working, again, all employees can request this, but again, you must have the minimum of 6 months continuous service before you can avail of the remote working. So you must be, it must be made as soon as practical, but no later than 8 weeks from when you want it to take place. The request for remote working must be in writing, signed by the employee, but may also be online. And it must include the details of the remote working arrangement, i.e. how many days and on which days are requested, and the proposed starting and end date of the arrangement if relevant, and the reasons for requesting the remote working. This is the employee's chance to set out to their employer how they are confident that they can continue to perform their role remotely to the required standard, and their individual specific reasons for making the request for remote working. So the right to request remote working, the code gives examples of reasons for requesting remote working, and include reducing the daily commute and carbon footprint, optimizing quality of life outside normal working hours, personal or domestic circumstances, neurodiversity, or special medical needs or circumstances which could favour a quiet working environment, or facilitates not always being available in the office. So the application must include details of the proposed remote working location. Example, are you going to work at home or at a work hub? And information on the suitability of the proposed location, which should include information on the following where relevant. So the workstation is suitably equipped and configured to enable the employee to perform the role and duties effectively. 2, the distance of the proposed remote workplace to the employer's on-site place of work. 3, the workstation that provides adequate privacy, which is really important. And 4, commit to ensure that the company data and intellectual property is secured and protected in accordance with the employer policies. 5, agree to comply with the employee obligations and to cooperate with the employer obligations in ensuring compliance with Safety, Health and Welfare at Work Act. And this was a huge concern, especially at the start of the pandemic. So it's a continuing obligation of the employer, so that you'll want to make sure that is adhered to. So agree to a risk assessment, and if approved, to make subsequent substantive changes to the workstation without authorization. Agree to show compliance with, but not limited to, data protection, data security, confidentiality, IT, social media, email protection of intellectual property, company policies, etc. You know, you take a lot for granted by being in a particular place in the office. So all of these things will also apply in the working from home scenario or the working from home. So 8 is the availability of relevant equipment and technology at the proposed location, and agree that equipment will be used appropriately. 9, confirm adequate and secure internet connection to perform the role, which may need to be assessed by the company's IT department. And of course, you don't need me to say that I'd be advising that. So the right to respond to remote working requests. So you must respond again 4 weeks, which can be extended by another 4 weeks, and an employer must approve the request and provide the notice in writing to be signed by the employer and employee, setting out the details of the arrangement, refuse the request and set out the reasons for the refusal, or request more time and tell them how long. So the employer must keep signed agreement and send to the employees. The employer can consider the needs of the business, the request, the reasons from the employee, and must consider the code when considering this request. And again, they must be fair, reasonable and objective when considering the request. So again, this is the timelines, and that's what the employer needs to consider. And so when you get that request in, just be mindful of the timelines, because that is what will be adjudicated in the WRC rather than the reasons for the refusal. Now, right to respond to remote working request. Considerations for the employer include the type of work, whether it is manual, does it require technology, which is on-site only, does it require interacting with clients in person, will this affect the quality of the work, any health and safety concerns. And I suppose it's a 2023 Act and a 2024 code, but we're 4 years into a remote working scenario. So employers are used to this now, I think it's fair to say. So the employer will also consider the employee when making a decision. If the employer can't agree, they should consider alternatives and engage with the employee and see if an alternative can be agreed. An agreement to remote working may change an employee's terms and conditions of employment. So that's again a consideration. And if the terms and conditions are going to be changed for a period of time only, if it's a short request, or if it's going to be a more permanent thing. So you need to consider all of that. Now, so termination, again, termination of the remote working. So an employer can terminate it, an approved arrangement before or after it has, as long as the employer is satisfied that the arrangement would have or is having an adverse effect on the business. The employer can give notice terminating the arrangement, having considered the business, the employee's need and the code. So the notice must set out the reasons for termination and specify the date on which the employee must return to their original working arrangement. This date must not be earlier than 4 weeks from the date when you want the employee to come back. So the employer who processes or who proposes to give notice of termination must first notify the employee in writing of the proposal to terminate and include details of the grounds for terminating. So of course it's reasonable to include the reasons and give the employee 7 days after receipt of the notice to respond, and then consider the response. The employer's reason must be clear, objective and reasonable. They should be set out so the employee can understand the reasons. Now, penalisation, again, an employee cannot be penalised for evading of the request if there's breaches, you can make a complaint under the employer's grievance policy. And I think that's where they want the WRC want this to be dealt with internally and through an employer's grievance policy rather than through the WRC. But an employee can make a complaint to the WRC. Again, like the flexible working, they will only adjudicate on the process rather than the merits of the decision. Awards up to 4 weeks' pay may be granted. And again, the employer must keep these requests and arrangements for up to 3 years for each employee, or face a fine up to 2,500. And there, I've just given you the link for the code. So that's that. Now, moving on to more fun topics, the AI Act. And by AI, I don't mean what we used to think it was years ago, was the artificial insemination. I don't come from a farming background, but I am in the country, and we used to talk about if the AI man was around. So this is different to AI. This is what we'll all be talking about soon, artificial intelligence. And it is all been talked about at the moment. So the AI Act, it's to govern the development, deployment and use of artificial intelligence technologies, and it's to ensure the AI systems are safe for the EU citizens. The provisions of the Act will apply on a phased basis over a 36-month period after the Act enters into effect. So what's important here, and I would, rather than getting bamboozled and bogged down with AI and fear, just have some key things to kind of remember about this. So the AI Act, they've identified 4 levels of risk, and I think 2 of them shouldn't bother you too much, and 1 not at all. Really, you won't be in that zone, and it's just the high risk. So B, we'll probably be focusing a bit on. So the 4 levels of risk are unacceptable risk, and these are systems that are deemed harmful and prohibitive. They are social scoring by governments, which is a horror show, and hopefully that they will continue to be prohibited. Manipulative or deceptive systems, compiling facial recognition systems, etc. And B is high risk. This is the one that you need to I suppose, zone in on. These are systems used in critical areas like healthcare, law enforcement, and transportation. These systems must meet strict requirements before they can be deployed. And then the limited risks are generative AI systems that require transparency measures, such as informing users they are interacting with AI, chatbots and virtual assistants, and we're familiar with them already. So, and then we have the lower risk, then is the minimal risk. That's the AI systems that pose little or no risk and have minimal regulatory obligations, obviously, because they're at low risk. So they're spam filters. Again, we are using them currently. Okay, so category B risk, I've jumped into that. So it can, as I said, it categorizes certain AI systems as high risk based on their intended purpose and the potential impact they can have on individuals and society. So Annex 1 and Annex 3 of the Act outline these high risk AI systems and provide specific details about the criteria and areas of application. So Annex 1 AI systems details the criteria used to determine whether an AI system is considered high risk. So high risk systems are those that pose significant risks to the health, safety, and fundamental rights of the individuals. The criteria include the intended purpose of the system, the impact on the rights and interests of individuals, the extent to which the AI system is used in critical sectors, and the regulatory, they require strict regulatory oversight. These applications are categorized into to several key areas. This is Annex 3. So there are 8 categories here, and 4 from the employment, number 4 from the employment perspective. we'll look at that. So number one is non-banned biometric identification and categorization of natural persons. These are systems, AI systems intended for real-time and post-event biometric identification of individuals in public places. Critical infrastructure, our governments already use these. They're used in the management and operation of critical infrastructure like energy, gas, electricity, and education. AI systems used to determine access to education or assess students in educational situations, and then the employment, workers management and access to self-employment. AI systems used in recruitment processes, making decisions on promotion and termination and monitoring employment performances. And 5, essential private and public services. These are systems determining access to essential services such as credit scoring, loan approval, and social benefits. And then 6, law enforcement. These are used by the authorities for risk assessments, profiling, and predicting criminal activities. Then 7 is migrant asylum and border control. These are systems used in border control, visa applications, and asylum processing. And 8 is in the administration of justice and democratic processes. These are systems used in legal decision-making process, which can impact individual rights and freedoms. So as you can see from that, these are quite serious, and it's rightly so. They have been put into a high-risk category. So the requirements for high-risk AI systems, so they must comply with several stringent requirements to ensure they are safe, reliable, and respect fundamental rights. So they have many hoops to jump through in order to get to the other end, basically. So you have to have risk management, implementing measures to identify and mitigate risks throughout the life cycles of the AI system. You have to have very strict data governance, ensuring the quality and integrity of data used, technical documentation, maintaining detailed documentation to demonstrate compliance with the Act. There must be full transparency, providing clear and understandable information to the users about the system and its capabilities and limitations. And this is, again, the crucial one for people, because they're frightened of AI, but we do need human oversight, and that is crucial. So ensuring that human operators can effectively oversee, and it is the overseeing role here that's important, and intervene in the system's operation if necessary. So accuracy, robustness, and cybersecurity, huge. Ensuring that the system is fully secure, obviously, no need to go on about that. So category C, these are the, as they go down the list, this is moving out of high risk. This is stuff that we're already using. So, but there are still some limits on it. So all providers of the generative AI models must draw up technical documentation, including training and testing processes, evaluation results, draw up information and documentation to supply to downstream providers that intend to integrate the Gen AI model into their own AI system in order that the latter understands capabilities and limitations and is able to comply, establish a policy to respect the copyright directive, and publish a sufficiently detailed summary about the content used for training. So key takeaways for employers. I'm not going to repeat the requirements there, because they're kind of duplicated, but you must be particularly vigilant about deployment and use of AI systems in the workplace, especially if these systems are categorized as high risk. Here are the areas of concern for employers. So you must ensure that any high risk AI system that you comply with the regulatory requirements. They include recruiting and hiring, performance monitoring and management, decision-making related to promotions, dismissals, or employees. So you have to conduct thorough risk assessments and ensure that the AI system meets the required standards for accuracy, transparency, and accountability. Implement robust data governance practices to ensure the quality and fairness of the data used by the AI system. So you must inform employees as well when you're using the system, especially in the context that affects their employment or performance. So you have to clearly communicate to employees which AI systems are in use and how they impact employment decisions. Provide information about the functioning of these AI systems and ensure employees understand their rights and the measures in place to protect them. The employers must ensure that AI systems used in the workplace are subject to human oversight. Of course, we've talked about that already. And establish protocols for human oversight and intervention. And I cannot emphasize enough, train, 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 train. It's going to be all about the training for this. So employers must use AI systems ethically, avoiding any practices that could lead to discrimination, bias, or unfair treatment of employees. And that is going to be the challenge for employers. So you have to regularly audit your system for bias and discrimination, etc. And then data privacy and security is huge. You have to just make sure that the integrity of your system is secure and strong data protection. And then there is the idea that you ensure about this, you can be held liable and caused, but this is not new for employers. You can be held liable for so many different breaches. So this is just a new one. And that's it. I've kind of flew through the end of it. And thank you if you've borne with me. I know we're over time and it isn't the easiest subject to talk about. So especially on a Monday.
Thanks, Hilary. We did have some questions. So just in relation to the remote working, must the employer support providing equipment and hardware, screens, chairs, etc. for a remote working request? This can be significant cost to smaller employers where a dual office setup is necessary. Is this enough to refuse a request?
Well, I'll answer that in two parts, Claire. I would say if you're going to go ahead with the request, yes, you have to supply everything. And by not supplying it, you're leaving yourself open to a claim under the Health, Safety and Welfare at Work Act that you haven't provided a safe system of work, and it would be foolish not to do so. Yes, it can be a reason for not acceding to the request because of the economies. And like, if you can see in the notes, like one of the first consideration are the needs of the business, and you know the costs on this can be significant. So if the business can't afford it, then yeah, that is absolutely a reason to refuse it, because yeah, you have to supply quite a lot of information and testing the systems at home, you know, getting your IT to make sure everything is okay. And yeah, totally.
Okay. I think that was it for questions.
Yeah, probably people are just afraid now of the AI thing. Don't be afraid, is what I will say. But there will be loads of opportunities for training, and but this is coming. But like GDPR, we'll be able to we'll get through it as well.
Yeah, we'll be able to.
Everyone was afraid of that at the start too. So yeah.
Totally. And I think it's just such a huge program of work to take on to even understand what the rights are before you implement any of these things in a business. There can be a bit of fear-based. Yeah, people are a little bit fearful. Well, look, Hilary, thank you so much. It's been another really informative session. I know there was a lot in that. So thank you so much to everybody who joined us today. We will be sending feedback forms to everybody. So please do provide us with any feedback that you have. It allows us to understand how these sessions are being received and how they can be improved. We'll share the slide deck with everybody, and you can review that at your leisure. And we'll also have a webinar replay that will be we'll send out, that you can send on to your colleagues or anything like that. Feel free to reach out to me directly if I can be of any assistance to you in the future. And Hilary's contact details are on the screen. So If you're not connected to either myself or Hilary, please do send us a connection request. We'd love to include you in our network and continue to include you in events and other exciting things that happen. And I hope to see you all at the next session. Thank you so much.
Brilliant.
Thanks.
Well, see you.
Bye.